Hello friends, in today's session we are going to discuss a case Masarullah versus State of Tamil Nadu was related to section 4 and 6 of the Probation of Offenders Act 1958, in which the question was raised whether a person below the age of 21 could be granted probation instead of imprisonment. The appellant was a member of lower middle class family aged less than 20 who fell into bad company, leading to his conviction under section 452 and 397 of Indian Penal Code. The session court sentenced him rigorous imprisonment, but the High Court rejected the appeal as a crime was premeditated. The Supreme Court examined the Probation of Offenders Act 1958 and ruled that in case of offenders under 21 years of the age, the court must analyze the nature of the crime, the circumstances of the case, and the character of the offenders. If imprisonment is imposed, the court must explicitly state the reason for doing so. The Supreme Court directed that the appellant should be granted probation and appear before the court within 2 weeks. He was also required to provide personal surety and two sureties, with one being his father. The court and probation officer were instructed to monitor his conduct. This case demonstrates the purpose of the Probation of Offenders Act is to ensure the rehabilitation of offenders under 21 years of age, providing them an opportunity for reform instead of direct imprisonment. Now let us study this case in details. Masarullah appellant versus State of Tamil Nadu respondent. Reference A.I.R. 1983 S.C.554. Subject of the case: the appeal pertains to section 4 and 6 of the Probation of Offenders Act 1958. The question under consideration was whether a person under the age of 21 could be granted probation instead of imprisonment. Fact of the case: the appellant was a member of a lower middle class respectable family and was under 20 years of age. His father was a retired teacher and his siblings were living stable social and economic lives. However, the appellant had failed in the 8th class. He was working as a carpenter in ECC, earning a salary of Rs 350 per month. He fell into bad company and developed criminal tendencies, partly due to his obsession with watching criminal themed movies. As a result, he was charged under section 452 and 397 of the Indian Penal Code. Decision of the Session Court: the appellant was tried by the Assistant Session Judge in Madras, who found him guilty under section 452 and 397 of the IPC. Considering the seriousness of the crime, the court sentenced him to 5 years of rigorous imprisonment under section 452 and 7 years of rigorous imprisonment under section 397. Decision of the High Court: the appellant filed an appeal in the High Court, arguing that since he was under 20 years old, he should be granted the benefit of section 4 and 6 of the Probation of Offenders Act 1958. The primary issue before the High Court was whether the appellant could be granted relief under the provision of Probation of Offenders Act. The court reviewed the charges against the appellant under section 392 read with section 397 and section 452. The court concluded that these offences did not carry a mandatory life imprisonment provision, making the case eligible for consideration under section 4 and 6 of the Probation of Offenders Act. However, the High Court rejected the appeal, stating that the crime was premeditated and not committed under sudden or uncontrollable circumstances. Hence, the court denied the appellant the benefit of probation. Decision of the Supreme Court. Against the decision of the High Court, the appellant filed an appeal before the Supreme Court with special leave. The appellant argued that he should have been granted the benefit of Section 6 of the Probation of Offenders Act 1958. The Supreme Court examined the provision of the Act in detail. According to the Act, in a person under the age of 21 is found guilty of an offence punishable with imprisonment except life imprisonment, the court should not immediately sentence them to imprisonment unless it is satisfied after considering the circumstances of the case, the nature of the offence, and the character of the offenders. The imprisonment is necessary. If the court imposes a prison sentence, it must clearly state the reasons for doing so. Furthermore, subsection 2 of section 6 requires that if the court wishes to grant probation under section 3 or 4, it must first obtain a report from the probation officer. The court must then consider the offender's character, physical and mental state, and other relevant factors to make an appropriate decision. Judgment. The Supreme Court directed that since the appellant was already released on bail, he must present himself before the Assistant Session Judge's Court in Madras within 2 weeks. The appellant was also required to provide personal bond and 2 sureties of 3,000 rupees each, one of whom must be his father. The court also ordered that the conduct of the appellant be monitored by the court and the probation officer. Finally, the appeal was allowed. Legal principle propounded. If a person under 21 commits an offence punishable by imprisonment except life imprisonment, the court shall not immediately sentence them to prison. The court must first analyze the nature of the crime, the circumstances of the case, and the character of the offenders. If the court is satisfied that imprisonment is necessary based on these factors, only then should a sentence be passed. Additionally, the court imposes imprisonment, it must record the reason for its decision. The primary purpose of the Probation of Offenders Act 1958 is to ensure the reform and rehabilitation of offenders under 21 years of age instead of sending such offenders directly to jail. The law offers them an opportunity for reform. This approach be preferred as it prevents them from associating with hardened criminals in prison, thereby reducing the risk of becoming more interested in criminal behavior. Please watch full video and share, subscribe. Thank you.